Hi, I'm Paul Goyette. I'm the founder and partner of Goyette, Ruano Thompson. And today what I'm going to talk about is how to win in high-profile criminal defense trials. Because we get asked all the time from a wide variety of clients, do we do trial work? Well, yes, we do. And what's the most effective strategy? So I'm going to touch on a few key points in this area so that you can decide whether your case is right for us to take it to trial. So I've done, since 1988, I have done quite a large number of cases that have gone to trial and to verdict in both state court and federal court. What I'm going to talk about today are high-profile criminal defense cases. Now, what does that mean? Well, that means typically cases that are unique, have very large consequences, or are most of the time in our case are people we represent who don't have any criminal records. We represent a lot of public safety employees, police, firefighters, nurses, teachers, etc., who get charged with crimes. We represent them. We also represent a number of white-collar, high-profile people of that nature. So what's the best way to go about this? Well, I've learned the hard way a lot of times how to do things and how not to do things. So the first thing what we do is we take a team approach. And so we will meet with the client and our whole trial team, which consists of me, some of my associate lawyers, our clerks and paralegals, will meet with you and go over the case and figure out, one, whether we want the case and do we want to work with you, and you got to figure out if you want to work with us. But we need to take this team approach and understand you and understand your case. Then what we'll do is conduct a thorough investigation. This is critical. Conduct a thorough investigation and do a bunch of research so that we have a comprehensive understanding of what all the facts are. And as importantly, in fact, even more importantly, is understanding what the charges are against you. Whether it's state court or federal court, you need to look at the charges very clearly, or the potential charges if they haven't been filed yet, and understand the elements. So each charge is going to have specific elements that are listed, 1, 2, 3, 4, that the prosecution has to prove. So you have to carefully analyze those and then look at the facts that we gather through our investigation and apply those to the elements of the charge. That's how it works. Any lawyers who do that at the back end of the case are doing it wrong and are going to do one thing, and that's lose. So once we get those initial steps out of the way, then you need to develop a strategy. And that is a simple strategy that passes the sniff test. If it sounds like BS to you and to us, it's going to sound like BS to the jury. So 52 cases I've taken a verdict. I believe that's the number. And one thing I do know is how juries operate. Juries are very diligent. They care, especially in cases that go on for more than a few days, which almost all of ours do. They get invested in the case. They want to make the right decision. So they understand things. I'm always amazed how thorough their understanding of the facts of the case and the law actually becomes when you get to the end of a case, especially a long case. So if your strategy doesn't make any sense, or if your strategy doesn't pass the sniff test with you, guaranteed it's not going to pass the sniff test with the jury, and they're going to say no very, very quickly. So those are some of the basics that need to be followed. Team approach, thorough investigation, pick a strategy. Some of the things you don't want to do is, and a lot of lawyers do this, is they do take the shotgun approach where they try to throw as much garbage against the wall as possible and get it to stick. Again, it doesn't work usually. Juries don't like it. They don't see it. They're confused. Very, very tough. When you do those strategies, when you apply that strategy, is when you don't have a defense, when your facts are terrible, and you're just trying to cause so much confusion that maybe you get lucky and you get a hung jury, and the prosecution can't prove up its case. But if you have a defense, and almost all of our clients do, you want to develop that defense and stick to it in a simple, understandable fashion. Also, don't run through a bunch of needless criminal procedure stuff, trying to recuse the prosecution or getting in huge discovery disputes unless it's absolutely necessary, because that doesn't move the ball down the field towards the goal. In fact, it creates a lot of animosity, but more importantly, it will cost you, the client, a ton of money that gets you nowhere. So that's also a component, because these cases are very expensive to defend. Now, I always put it this way. If you need to have heart surgery, and if you don't have the heart surgery, you're going to die, you're going to spend whatever money it takes to keep yourself from getting buried at the cemetery, right? Of course you are. Same thing on a serious criminal defense matter. In fact, maybe even more so, because if you die and you're dead, you're not going to know one way or the other. But if you're going to jail or prison especially, that ain't going to be any fun. So you're going to spend the money it takes. So that needs to be done efficiently. But they're very expensive cases and very time-consuming cases to defend if you want to do it right. And if you're going to do it right. Not only are there tons of attorney fees hours involved, but there's expert witnesses that are involved. And oftentimes a lot of investigation and transcripts and investigators and so forth that are important to set up the best strategy to handle your case effectively. So we get asked those questions a lot. I want to do something for you all today so that you could see that. And if you have a case that you need help on, reach out to us, contact us, and that we'll get some of our team members back in touch, and we'll see what we can do for you.